The first discussant is Professor Becker. You have the floor.
Thank you. Well, good afternoon. Like those who've spoken before me, let me just begin by expressing my gratitude to the organizers, to the Ministry of Foreign Affairs, to the Korean Society of International Law, to ITLOS. It's been such a privilege to participate in these sessions, and I thank you for the invitation and for putting together such a well-organized event. And it's also an honor to be asked to comment on the remarks of two distinguished scholars whose work I have been learning from for a very long time. So I want to make four broad points that I think are, or at least I hope, loosely connected to each other and respond to what both Professors Rothwell and Oral have said. So my first point is that we are living, or it seems we are living, in an age of advisory opinions, or at least in an age of proposals for seeking advisory opinions. It sometimes seems that any international problem that comes up, well, there's somebody who sees obtaining an advisory opinion from one international court or another as a valuable part of the solution to that problem. And so just looking beyond ITLOS for a moment, in recent years, we've seen all sorts of proposals that haven't come to pass, but proposals for seeking advisory opinions from the International Court of Justice. And this is included on topics such as a perceived conflict between obligations under the Rome Statute of the International Criminal Court and the customary international law rules relating to head of state immunity from criminal jurisdiction. We've seen proposals for advisory opinions relating to state responsibility in connection with issues arising from the COVID-19 pandemic. We've seen proposals for advisory opinions on the legal consequences arising from very specific situations and conflicts, including Russia's war of aggression in Ukraine, or the situation in Xinjiang in China. And just last week, as was mentioned earlier, the Fourth Committee of the UN General Assembly took steps towards putting a new request to the ICJ relating to the situation in Palestine. We are all aware, as has also just been discussed, that a request to the UN General Assembly going to the ICJ relating to some issues relating to climate change also seems imminent and is perhaps something that will follow on from the close of COP27 next week. So these have been proposals. And then on top of this, we have the actual advisory opinion activity of international courts and tribunals. So we've talked already in previous sessions about the Chagos advisory opinion from 2019, but we also have, I think, the extraordinary way in which the special chamber of the ITLOS relied upon that non-binding opinion last year to dismiss the preliminary objections in the Mauritius versus Maldives case that remains pending. The special chamber's decision there to interpret the legal effect of the ICJ advisory opinion as having resolved that sovereignty dispute over Chagos is certainly notable for how it tries to navigate the tricky conceptual distinction between judicial decisions that are formally binding and then other legal pronouncements that are in that difficult category of being non-binding yet authoritative. But I think Mauritius versus Maldives is also notable for perhaps what it says about the tribunal's own view of the authority that advisory opinions carry, as well as perhaps the tribunal's own view of how it can best fulfill its function. That is to say, an approach that privileges the overall effectiveness of the UNCLOS regime, perhaps at the expense of more formalist notions of treaty interpretation or the law of sources. And the special chamber's move in Mauritius versus Maldives is even more remarkable, given that in the SRFC opinion that Professor Oral has just been taking us through, the tribunal emphasized the non-binding nature of advisory opinions in pushing back against some of those objections that states raised to the exercise of its plenary advisory jurisdiction. All right, that was a bit of a digression here. In any event, the ICJ is not the only game in town when it comes to advisory opinion activity. The regional human rights courts are also very active in this area. So since 2018, a new protocol to the European Convention on Human Rights allows states to authorize their highest courts, their supreme courts, to seek advisory opinions from the European Court of Human Rights relating to the interpretation of the European Convention that arise or have arisen in a pending case. So a procedure that resembles in several ways the preliminary reference system under EU law. And that new procedure has already been used twice. But by far the most active advisory opinion provider over many, many years now has been the Inter-American Court of Human Rights, as Professor Earl mentioned. The American Convention on Human Rights authorizes the court to give advisory opinions on the interpretation of the American Convention, the interpretation of other treaties concerning the protection of human rights in the Americas, as well as the compatibility of domestic laws with those international instruments. And while OAS, so Organization of American State organs, are authorized by the treaty to seek advisory opinions, it was actually the Inter-American Court itself that declared that any OAS state can also seek an advisory opinion. So we have here an advisory opinion procedure that contains even fewer constraints on its use than what I would describe as the relatively low threshold created by Article 138 of the ITLOS rules. And so in the Inter-American Court context, this has generated further opportunities for that court to shape the law in significant ways through the use of its advisory function, including in its 2018 advisory opinion on transboundary environmental harm, something that might be relied upon or invoked if we see one of these climate change advisory opinion requests come either to the ICJ or the ITLOS. Finally, I'll just on this first point note that the International Criminal Court, moving around different international courts and tribunals here, has also, well, has so far declined invitations to render what would really amount to advisory opinions, but in doing so, it has signaled very recently that in principle, it could do so if the Assembly of States Parties sets up the right mechanism to facilitate this. I mention these examples just because I think there is a tendency when we think about and talk about the ITLOS advisory jurisdiction to mainly compare it with the ICJ. But there's a broader world of advisory opinion practice to consider when it comes to these questions of procedure, legitimacy, and effectiveness. So for better or worse, this is happening. And I would say it is hastening a kind of breakdown between binding judgments and, again, that category of non-binding but authoritative guidance. Okay, my second point is that, like Professor Rothwell in particular, well, Professor Earl mentioned this as well, I've been really struck by the enthusiasm for advisory opinions at this conference. Starting right from President Hoffman's opening remarks and Judge Pake's keynote speech, and continuing through several of the different sessions, there appears to be a pretty strong feeling in the room that advisory opinions are key or even essential to making the convention effective for the next generation. President Hoffman not only mentioned the possibility of a climate change advisory opinion, but also perhaps at certain points in the BBNJ treaty under negotiation might benefit from an advisory opinion. He pointed to the potential utility of an advisory opinion by the seabed chamber on procedural issues relating to the 2-year rule and completion of the rule book. And then in the very first session, Professor Tanaka identified the need to clarify that military activities exception in Article 2981B. And then Professor McGarry suggested expressly that an advisory opinion might be useful in that respect. And then in other sessions, I tried to keep a running list of this throughout the last couple of days. There were additional areas of uncertainty or controversy in UNCLOS where I thought the speakers, if they didn't expressly mention the advisory function, seemed to imply that some kind of advisory guidance on those issues might be helpful. So take yesterday's session on delimitation, for example. What about seeking guidance from the tribunal in relation to the selection of base points, that problematic step 0 in the 3-step process? Or what about, we've heard a lot now about the difficulties associated with delimitation of the continental shelf beyond 200 nautical miles. What about calling upon the tribunal to resolve this stalemate that has been created by the Commission on the limits of the continental shelf's rule that it will not make recommendations on submissions relating to disputed areas? That's created a situation that then Judge Donahue, in her 2012 separate opinion in Nicaragua versus Colombia, likened to the ICJ and the CLCS, each holding the door open and waiting for the other to walk through it, since the court finds itself in a difficult position when faced with disputes about delimitation beyond 200 nautical miles and no recommendations from the Commission on the delineation of outer limits to refer to. Now, I'm sure all of you can think of many other areas of uncertainty that might seem like candidates for an advisory opinion. I can think of several. What about an advisory opinion on, say, the compatibility of Japan's ongoing whaling practices with its obligations under Articles 65 and 120 relating to the conservation and protection of marine mammals? Or how about an advisory opinion on the rights and obligations of coastal states when it comes to military exercises by third states in the EEZ? This is an issue that arose in Ireland, where I'm based, earlier this year, when Russia, a few weeks prior to its invasion of Ukraine, announced plans, which were then subsequently abandoned, to undertake military exercises in part of Ireland's EEZ, much to the ire of Irish fishermen. Okay, this gets to my third point. I think it remains fair to question whether this unbridled enthusiasm for recourse to the full tribunal's advisory jurisdiction is necessarily a good idea. So I'll try to address this relatively briefly, not to dismiss the value and potential of that advisory jurisdiction, but rather maybe some reasons to proceed with a degree of caution or restraint. So first, there's the basic idea which Professor Rothwell hinted at in his very final remarks. The outcome of an advisory opinion proceeding may not be what you want or expect. So on the one hand, an advisory opinion maybe simply won't have much impact, especially if a high-level abstract question leaves the tribunal unable or unwilling to do much more than provide a high-level and open-ended response. But there's also the risk that an advisory opinion might slow down or even stop the development of the law or undermine the original objective behind the request. So, as Professor Rothwell suggested, there's a need to be careful what you wish for and not to assume that an advisory opinion is necessarily going to go your way. But the other side of the coin here is that an advisory opinion might actually give you too much. The interpretation or conclusion reached by the tribunal might be so out of step, might move too fast, it might be beyond what states are willing to accept politically, and therefore create backlash and ultimately diminish in some way rather than enhance the tribunal's effectiveness and the regime's effectiveness. There's also a normative question here. Is this how we want to see the law of the sea developed? Through a series of advisory opinions? Are advisory proceedings well suited or better suited to the interpretation of UNCLOS provisions than are judgments reached in the context of real concrete disputes? Disputes that require judges to work through actual, not hypothetical, situations of fact. It might be my own common law training, but I tend to gravitate towards the idea that law development through contentious cases, even if incremental, might be more likely over time to generate a durable body of law. I think there's some value in legal arguments being tested in an adversarial setting, contrary to what Professor Oral has just suggested. But that's open to debate, and my own view might be more a product of my intuition rather than anything else. There's certainly an argument that simply creating more opportunities for the ITLOS and its judges to bring their expertise to bear is inherently a good thing. And I think that the more that an advisory proceeding functions as a multilateral collaborative process involving a range of actors, and less as a kind of delegation of interpretive authority to the ITLOS in the face of political deadlock or political apathy, well, the more likely it is that advisory opinions will make a positive contribution. There's also an empirical question here. What is it that actually makes an ITLOS advisory opinion effective? So Professor Oral has walked us through the SRFC opinion, and I agree with her that the tribunal's identification of the flag state due diligence obligation was a logical and sensible interpretation, a way of updating the convention. In fact, I think it's quite interesting that both the area opinion and the SRFC opinion have really focused on due diligence obligations, which are, of course, a very useful way to embed international obligations into domestic legal systems. I mean, one of the ways in which advisory opinions can be most effective is perhaps by providing litigants in domestic courts, and indeed judges in domestic courts, with interpretations of UNCLOS that they can draw upon in that domestic context. That might be especially relevant for climate change litigation, because we know there's a lot of activity that's already taken place and is continuing to take place in domestic courts. And so when a litigant challenging climate change related legislation at the national level can point to something that the ITLOS has said on this, well, that might be a useful thing. Now, going back specifically to the SRFC opinion, I agree with Professor Oral that its substantive conclusions I don't think were controversial and have been broadly welcomed by states and NGOs, but I'm not sure how effective it has actually been. So we have this identification of the due diligence obligation. That laid the groundwork for contentious cases in relation to illegal fishing, contentious cases about flag states that haven't met their due diligence obligation. But we haven't seen any contentious cases under UNCLOS dispute settlement relating to flag state due diligence obligations. Why is that? We know it's not that illegal fishing has suddenly disappeared. And nor is it clear that flag states, especially open registry states, have actually made legal or policy changes in response to what the ITLOS said in the SRFC opinion. And I think that's a reminder that while, as Professor Oral emphasized, many states took part in those advisory proceedings, they didn't involve the most significant open registry states, states like Panama, Liberia, and so on. Finally, I would just ask my fellow panelists and people in the audience whether the ITLOS is necessarily always the best placed entity to deal with some of these issues that I've mentioned. There is this question of, well, can the meeting of the states' parties play a more prominent role in updating UNCLOS? Maybe. Well, and what about the ILC? What if there's an overlap between the work of the ILC and an ITLOS advisory opinion request? I imagine that as the ILC member of our panel knows very well, the ILC is actively engaged with some novel legal questions relating to climate change in the oceans, including on sea level rise. So would there be a case for deference or abstention by the ITLOS in a situation like that? Should the collaborative, deliberative working processes of the ILC be allowed to play out? Or would an ITLOS advisory opinion in the midst of an ILC study be a welcome development? I'm sure there are people maybe on the stage and not on the stage who would have views on that. So I'll conclude with one final point. I have some reservations about over-reliance on the advisory function. For full disclosure, I am one of the commentators who was very critical of the way the court, or the way the tribunal justified its exercise of the plenary jurisdiction back in 2015. But I can also see the potential benefits here. And if there's widespread agreement that this is the way to go, that this is the way to ensure the effectiveness of UNCLOS going forward, well, then I would put to you that maybe the current procedure embodied by Article 138 of the rules isn't the optimal way to facilitate this. Maybe rather than requiring states to enter into these international agreements for the sole purpose of requesting an advisory opinion, can we envision a different procedure that would allow states to request an advisory opinion directly? Now, amending the convention is a non-starter, I think, but I wonder whether a protocol instrument could dispense with this fiction of setting up new entities to request advisory opinions, and could instead allow for a more direct procedure, and maybe one that introduces or reintroduces some measure of control, perhaps by putting in some kind of threshold requirement in terms of the number of states that need to be involved. An ITLOS advisory opinion mechanism like that would look a little bit more like the procedure for requesting an ICJ advisory opinion through the UN General Assembly. And maybe this would go some distance towards addressing whatever lingering discomfort there might be over how the full tribunal's advisory jurisdiction can currently be called upon. Thank you very much. I hope that that contributes to the discussion, and I will turn it back over to our chair.
Thank you, Professor Becker, for your comments. I now give the floor to Professor CHOI.
Thank you. I want to deliver my special gratitude to the three organizers, Ministry of Foreign Affairs of Republic of Korea, and ITLOS, and the Korean Society for International Law, for giving me these wonderful chances to have a discussion in front of many well-known guests and prominent presenters. Today, this sixth panel's theme is the advisory opinion of the ITLOS. I will make this long slide short because last panel, my hand was rejected by the moderator because of the time limit, so I want to make this slide short to have enough time for the discussion. So I will skip this part, but in the jurisprudence of ITLOS case number 21, it focuses on this other agreement, Article 21, and the other agreement conferring jurisdiction on the tribunal are interconnected and constitute the substantive legal basis of the advisory jurisdiction of the tribunal. And also it mentioned there is the rule of the tribunal, Article 138. It elaborates the prerequisite of this advisory opinion. And also this prerequisite already mentioned by the Professor Nilüfer in her presentation, so I will skip this point. But if I summarize the case of this ITLOS case number 21, SRFC advisory opinion, the first requirements, the other agreement, it was the MCA convention, and in the preamble, you can see that some relation or we can see that some object and purpose of this MCA convention. We can easily find out this MCA convention closely related with this United Nations Convention on the Law of the Sea. And second point is that this requirement must be transmitted to the tribunal by a body, authorized body. In the case of this number 21 case, in the Article 33, the MCA Convention, Conference of Ministers of the SRFC may authorize permanent secretary of the SRFC to bring a given legal matter before the International Tribunal for the Law of the Sea for advisory opinion. And third one was these legal questions. Already you saw the Nilüfer's presentation, 4 questions, obligation of state of IU fishing, etc. And today, in my discussion, I want to put my stress on this alternative dispute settlement mechanism and the climate change issue. First of all, this alternative dispute settlement mechanism. And when you look at this, when you read this SRFC advisory opinion, you can find out some features as an alternative dispute settlement procedure. First point is that only a small number of state parties can initiate an advisory procedure. Comparing with the ICJ advisory opinion, we must have the majority voted from vote from the General Assembly or Security Council. But in the case of ITLOS, only a small number of states can take this some legal question to the advisory procedure. In case of this SRFC advisory opinion, only 7 number of states in the Western Africa, they take this legal question to the ITLOS advisory opinion. And second point is the jurisdiction or scope of legal effect. According to paragraph 154, its jurisdiction in this case is limited to the exclusive economic zone of the SRFC member state, and scope of this question is limited to a flag state or international organization has concluded officially access agreement with a state party, in this case it was the EU, to the MCA Convention. So legal scope or jurisdiction was narrowed down only to these 7 member states of SRFC. And also there is third point, even though it is not a majority opinion against this minority opinion, but in this minority opinion by the judge court, he made some declaration and he wanted to make some movement toward another alternative dispute settlement mechanism. It was a denial of discretionary power. According to his declaration, paragraph 5, my main reservation concerned the refusal by the tribunal to exercise its discretionary power to answer or not to answer question referred to it in advisory proceedings. When we remind these 3 features, it is different from ICJ advisory opinion. It is much closer to a kind of dispute settlement procedure or an alternative dispute settlement procedure than ICJ advisory procedure. And I will look over some scholarly opinion. Before 2015, the former judge and president of ITLOS, Wolfram, already mentioned by Professor Nilüfer, according to his article, advisory opinion are not designed to directly settle international dispute. They do it indirectly by establishing fact, breach of international legal standard, etc., etc. And the former deputy registrar ITLOS, Jee-hyun Kim, he wrote an article, requirement for the request for an advisory opinion of the tribunal look more flexible, and such flexibility seems to provide state parties with additional opportunity for the settlement of dispute relating to law of the sea matters. And altogether, there is a concern in the article of Judge Wolfram, the conditions set by Article 138 of the Rules of the Tribunal for submitting a request constitute high threshold, which makes it rather unlikely that states may use these options. And after 2015, my colleague, Professor BECKER, he wrote some article in American Journal of International Law. He mentioned advisory opinion highlight the extraordinarily broad scope of the full tribunals you found advisory jurisdiction and raised the prospect of the submission of any number of novel and important questions. To sum up this scholarly opinion, there was expectation before 2015, right after 2015, if ITLOS full course allows an advisory opinion, it could open new gate for an alternative dispute settlement mechanism, and there was some concerns also that Article 138 made very high legal threshold to the advisory opinion. In the other way, an alternative dispute settlement mechanism could have a highly politicized character. And next one is the current issue of this climate change. And Professor Donald Rothwell and Professor Nilüfer Oral already mentioned the climate change issues with regard to this ITLOS advisory opinion. When I want to share the current use of this climate change, and COP26 meeting in Glasgow last year, 2021, Antigua, Barbuda, and Tuvalu signed the agreement for the establishment of the Commission of Small Island States on Climate Change and International Law. According to this Article 2, Paragraph 2, having regard to the fundamental importance of oceans as sinks and reservoirs, greenhouse gases, and the direct relevance of the marine environment to the adverse effect of climate change on small island states, the Commission shall be authorized to request advisory opinion from the International Tribunal for the Law of the Sea on any legal question within the scope of the UNCLOS, consistent with Article 21 of the ITLOS statute and Article 138 of its rules. And this year, COSIS, they made these three heads of government made some statement, and they decided to express full support for the separate Vanuatu initiative to seek an ICJ advisory opinion on climate change through an UN General Assembly request. When you look over this event in the September 2021, Prime Minister of the Republic of Vanuatu formally announced Vanuatu's intention to pursue a request of an ICJ advisory opinion through General Assembly on the right of current and future generation with regard to climate change. I want to add my question and comment with this alternative dispute settlement mechanism and climate change. Question one is, will COSIS try to submit the request of a climate change issue to the ITLOS advisory procedure? Why does COSIS comment in this year that it will support Vanuatu's intention to request ICJ advisory opinion instead of trying ITLOS advisory opinion by itself, by COSIS itself? First, we can think about the scope of the ITLOS advisory opinion. ITLOS only can cover law of the sea issues and the change of maritime area and maritime delimitation and change of status of island and rocks. But it seems that it cannot deal with statehood issues and human rights issues under the UNCLOS scope. Secondly, we can think about the political status of General Assembly in the international community. If General Assembly take the climate change issue to the ICJ advisory procedure, it will draw more attention from the world. So if COSIS is in the same page with Vanuatu or other small island country, it will wait for the resolution of General Assembly. That is my short comment, but our distinguished panelist, Professor Nilüfer Oral, she has much experience to deal with climate change and sea level rise issues in the ICLS as a special rapporteur, so it will be welcomed by me and audience to share your idea and experience together. And also Professor Rothwell, we will wait for your answers altogether. And second question is it possible or wise to take this climate change issue to ITLOS advisory procedure and ICJ advisory procedure simultaneously? Already Professor Rothwell shared his view of the simultaneous submission to those two advisory procedure of one ICJ in the other ITLOS. He showed us his concerns of fragmentation of two advisory opinions. Yes, I agree with his opinion. There will be a possibility of conflicts of advisory opinion. If then, what is the best scenario to deal with this climate change issue in two world courts, ICJ and ITLOS altogether? That was my second question. And the third question is, what is the reasonable normal submission to ITLOS advisory procedure since 2015? Even at the time, we have many expectations there would be more submission of ITLOS advisory opinion. And or can we expect more prosperous activities of state parties submitting an advisory opinion to the ITLOS? Judge Bolfrom I already mentioned to you, made a kind of prophecy that Article 138 put too high threshold for ITLOS advisory opinion. So today, normal submission to the ITLOS advisory procedure, it shows us that his kind of prophecy is fulfilled. If then, too high threshold itself, that is the only reason why there has been normal advisory procedure since 2015. If you have any information or if you have any views, please share your opinion together with us. And fourth question is should an advisory procedure of ITLOS be an alternative dispute settlement mechanism, or should the jurisdiction of the ITLOS or its legal effect only cover some number of states initiating advisory procedures through an authorized body? As we can see in the case number 21 of SRFC advisory opinion, it only covers the EEZ of SRFC member state and flag states of fishing vessels in those EEZ. That seems not reasonable in case of climate change and sea level rise. There is no reason to make advisory opinion only covers those three states, Antigua and Barbuda, Tuvalu, and Palau. And this climate change and sea level rise is not a legal question of bilateral character. This issue shares a common interest of all states. If any specific obligation could be extracted from this climate change issue, then it could have erga omnes character. And also, Professor Nilüfer pointed out many states can participate to this advisory procedure. So there is no reason to narrow down its scope and legal effect to my humble knowledge. That is to my humble knowledge. And that is the end of my question with my short and humble observation. Please cover my question with your enlightening answers. And if there is any blank or deficiency in my observation, please fill it with your wisdom. Thank you for your attention.
Thank you, Professor Choi. Before taking questions from the floor, I think maybe the main speakers would like to comment or make on the questions raised.
Thank you, Chair. Before I directly address the questions, I'll just say, Professor Becker, I broadly agree with many of the observations you've made. One of the thoughts I had as you addressed that final point in the four substantive points that you've made is there not a capacity for the rules of the tribunal under Article 138 to be adjusted? And of course, the rules of the tribunal have been adjusted and modified over the lifetime of the tribunal. So that might go some way to addressing some of the issues that you've raised. Professor Choi, thank you for your questions. I won't answer all of them because Professor Orrell has some more insights on some of those matters than I do. I think you're right that in theory there is the potential for simultaneous advisory opinions. I think on the other hand we do have to accept that there's a significant political and diplomatic effort associated with seeking to pursue and advance advisory opinions. As Professor BECKER reminded us, there's been discussions about multiple advisory opinions on multiple different issues across multiple different areas of international law over the last decade and certainly over the last few years, and yet how many of those have come to fruition. So to that end, I think we need to be cautious about thinking that whilst hypothetically there might be the potential to see simultaneous or equivalent advisory opinions going before the ICJ and ITLOS, whether that would actually occur, I might find to be doubtful. Why hasn't there been more advisory opinions since 2015? I can't answer that question, other than to refer back to what I just said. That is, that we need to accept that there's a lot of effort on the part of diplomats, the international civil society, and relevant international organisations to generate the momentum for advisory opinions, and the energy may not just have been focused on that issue, and I think that most of the international community has been significantly diverted by another major international issue over 2020 and 2021, which has enormously impacted the workloads of foreign ministries to advance some of these matters. And if we just think about the delays in the fairly well advanced negotiations for a BBNJ agreement, that indicates that issue. The final question was whether or not advisory opinions, should they be an alternative to dispute settlement? And I think quite clearly the answer must be is that yes, advisory opinions do provide from time to time a mechanism to ventilate and to discuss and to get an authoritative determination by a respected international court and tribunal of a very significant issue of international law. And we can think of many advisory opinions where the ICJ has played a pivotal role in terms of being able to give a legal perspective on critical issues impacting the international legal community at a particular point in time, which could not otherwise have been subject to international litigation before the court. So to that end, whilst formally advisory opinions do not resolve disputes, they may play a constructive role in terms of the resolution of a dispute or move forward diplomatic processes for dispute resolution. Thank you.
Thank you. Okay, it's on. Thank you very much, and I first compliment both of the discussants for their excellent points that they've raised, and impossible to address all of them. Plus, I have a very bad memory and take poor notes, but I'll do my best. So first of all, Mike Becker's comments, and I think you did a very good job in giving us a comparative approach and not to be focused solely on, ICJ and ITLOS. It's very true. There are other fora where advisory opinions are used. And so I think that's very helpful. And indeed, when we look at the current enthusiasm, as we say, for advisory opinions, maybe I take a different look, as I think it's also enthusiasm for international law, actually. There's the initiative now for Vanuatu, for the ICJ for climate change. And this initiative is coming from law students. It started from law students in law school in Vanuatu. I think this is an enthusiasm we should really welcome. That is the next generation. And they are showing a faith and belief that an international court of justice may actually provide some insight. I don't think we can look at advisory opinions as solving the problems of the world. Certainly not. And what I'm concerned about, as we discuss, advisory opinions are one of the tools that international law has to offer. And clearly, when we look at the history of advisory opinions, which Professor Rothwell gave us from the Permanent Court of International Justice, some 28, the current ICJ, I mean, there has been, and each one of those has raised objections from states, and how many have been, how many advisory opinions have been rejected? One in the Permanent Court of International Justice and one in ICJ. So clearly, I think that to me, it's easy to be very critical, and I don't mean that in a flippant way, but I think that's why I want to try and look more at what is the constructive role of advisory opinions. And when we look at those criticisms, for example, for the IUU fishing, because of Rule 138, and some feeling it was actually a low threshold. Well, now two states are going to get together and come up with an agreement and seek an advisory opinion. That didn't happen. I think sometimes perhaps we're exaggerating these fears and instead looking at, but there's truth as well. For example, why more advisory opinions didn't come out. I also agree we expected, actually, why a contentious case didn't resolve. But those are political issues. There's more politics behind that than actual legal issues. So I think that these are all valid. When it comes down to the questions that Professor Choi has asked, and also I think Professor Becker on the ILC sea level rise and the work we're doing on climate change, the mandate of the ILC is limited, actually. We're looking at specific issues. We're not looking at environmental issues. We're not looking at issues of liability. We're looking specifically, and right now it's a mapping exercise. So I don't think that we run into the potential of overlapping or conflicting. And I know that we have here Omri Sender, who's written extensively on the relationship between the ILC and the ICJ. So I don't see that really as a risk at all, and I like to think perhaps there's complementarity there. But the very interesting questions that you posed and in terms of COSIS, and I have to say that I'm actually one of the members of the legal expert group of the COSIS, the Commission. And the Commission's objective is not only to seek an advisory opinion, but it was given that mandate. And you asked the question of why the three heads of state, actually now there's a fourth party, NUI, and there's anticipation that there will be more AOSIS states becoming party to the agreement, but that the two initiatives are mutually supportive. And again, taking the view that we have many tools. It is not one or the other. It's not ICJ or ITLOS. It's not contentious or advisory opinion. It's really maximizing those tools that are there. And so it's important that, in fact, one member of the Vanuatu is also a member of COSIS, that they will be mutually supporting each other. But of course, the COSIS is restricted more to ITLOS. And I think this will be coming out soon, though. I think you will have some interesting news coming out soon from COSIS. So let's see. Have I answered most of the questions? That's all I can remember right now. But those are my views, and I really do appreciate that we do have to be cautious. I do not disagree with that at all. The question is absolutely essential. If you ask the wrong question, we know as lawyers, this is, for lawyers, the right question is critical. But I think that that should not negate the use of advisory opinions, but instead, it should simply be the framework of caution. And it is an interesting idea, I will say, on a possible protocol. I just wanted to add that the BBNJ agreement will likely include a provision for advisory opinions and probably will include some kind of threshold number, similar as we know with Part 11. So I'll just stop there. Thank you.
Thank you. We have a few minutes if there are questions or comments from the participants. Yes, I see Professor there.
Thank you, Mr. Chair. And congratulations on the Foreign Ministry of Korea and the Korean Society of International Law for organizing and implementing this important conference. My name is Dr. Hyunjin Park. I would generally like to concur with the two speakers. The theme is very relevant and appropriate. I think especially the significance and the impact or effectiveness of advisory opinions is quite interesting topic, wrapping up the whole issues of this conference. Advisory opinions are per se are not binding law, I think, but represent collective legal opinion based on legal consensus and handed down by a competent legal authority. In that sense, it offers another route to solving or resolving some potential disputes. Although it is not an adversarial or contentious case resolution of disputes. Secondly, in that sense, advisory opinions is a minimum moral code of conduct for state parties. It is a clear guidance and clarification for the purpose of interpretation and application of convention rules. As you know, Professor Henkin's theme or aphorism, most countries comply with international law most of the times. I agree, but there is always some potential violator or objector in the gray area. And in this sense, this, as Professor Rothwell has already pointed out, advisory opinions gives a warning or deterrence and promotes state practice conducive to developing into a desirable course of action for states. Thank you very much indeed.
Thank you. So I see some red light here, and I'm afraid we may have to close before I give the floor before I pass on to Mr. Kim. I want to thank the speakers and the discussants for their contribution. Thank you very much.
Thank you, Judge KATEKA, and all the speakers for the wonderful speech and discussions. Please give a big round of applause for all the speakers on the floor and the moderator. Thank you. Now, ladies and gentlemen, that brings us to the end of session 6, as well as the end of all the sessions we have prepared for you for the 7th International Conference on the Law of the Sea. I would like to thank all the distinguished participants who have joined us both online and offline, and I have no doubt that it was a precious time for all of us sharing our experiences and thoughts on our common concerns. Once again, thank you for your participation, and we look forward to seeing you again for the next year's session. Thank you.